Hi, in this video we're going to discuss contracts and what can be included in them when doing them for your clients. This is mainly geared towards agencies or people who work with businesses and provide services or software or build things or content or write or any type of interaction with a client. Now, remember, I'm not an attorney. This is not advice. It is for educational purposes only. I'm sharing what has helped me in the past. Consult an attorney before implementing any of this information. My name is Akehurst. There's my contact information on there, and I'm going to repeat my legal disclaimer. I am not an attorney. This is not advice. Nothing in here is to be construed as advice. This is simply for educational purposes. I get asked a lot by people I work with to show me your contracts. What do you put in your contracts? So I am going to share what has helped me in the past and what I do. But remember, I'm not an attorney. So before you use any of this information, if you want to make sure you're legally covered, I do recommend you consult an attorney. There's no problem with writing your own contract, but run it by an attorney before you actually put it into use. I do recommend that. All right, consult an attorney. I'm going to go over 14 different points to consider when drafting a contract, and remember, legalese is not required. The contracts can be in plain English. Attorneys sometimes like to write them in deep legalese and make them as long and verbose as possible, but there's nothing that says it has to be that way. So I write most of mine in plain English, and then of course have an attorney review it. So let's get into those 14 points. Names. Contracts have to have the names of the parties. Who is the contract between? Make sure the names are legal names. If you're doing a website build, for example, for Joe Smith, then it would be Joe Smith. But if you're doing it for Joe Smith's plumbing company, then the legal name on the contract would be Joe Smith's Plumbing Company. And he would simply be the signer, assuming he's the owner or manager. Definitely put the addresses in there, and then I like to put preferred contact methods. If people prefer to be reached by text or email, make sure that's noted and that information is available and in the contract. That makes life simpler. Duration. Contracts need to have when they start and when they stop, so put those dates in there. It's possible they're not dates, they may be events. For example, it might start when the first payment is made, or it might start immediately upon signature, or it might start the first of next month. Whatever that is, put that in there. And if there are completion requirements, for example, a contract might be finished in a year if it's simply managing their ad account or something like that, or if it's letting them use your software, for example, that might have a firm date, but it might also have a completion requirement. For example, I'll use the example I gave in the previous slide. If you're building a website for a client, it'll go until the website's built and until both parties are happy with it according to the terms of the contract. If there are interim deadlines, for example, in my line of work, we do lead gen and lead follow-up and automation systems and things like that. We might say, if we're doing the whole kit and caboodle for them, we're doing all the work, we're not just letting them use the software, maybe we have a week before we get all their phone numbers in and their campaigns built. We have another week to do testing. If we're driving ads, maybe we have another week to get the ads up and running and another week to test them and get them to the percentages that we want before we start running them for the client. So whatever interim deadlines you might have. Again, if you're building a website, maybe you have to have all the design work, the basic design work done by a certain date and the content done by a certain date, etc. So whatever that is, start and stop dates, completion requirements, interim deadlines. The next point is the scope of work. This is usually, in most contracts I've seen of this nature, the longest part of the contract. I mean, this can be pages. The work I do now, it's usually a page or two. We used to do contracts when we were doing real estate investing and we were doing remodelings and things like that. Those could be 20 pages, depending on the level of work that we're done. So put in there what's being done, and you may also want to put what's not being done. And what I mean by that is, again, let's use the website example. Maybe you're building a website and you're going to have a page with testimonials. Is it your job to go get those testimonials, or are you going to simply rely on being provided those testimonials by the client. So you're putting the testimonials on the website, but you're not getting the testimonials. And in a case like that, if it was me, I would want to make very clear of that. If they're providing images, if you're going to put the images on the website or on the ad or on their social media, if you're managing social media for them, that's great, mention that. But if you're not actually providing those images, make that also noted. Be specific, be detailed. The more specific and detailed you are when putting things into the contract, the less problems you're going to have down the road. Okay, that really is, full transparency, full disclosure, specifics, details, all of that really helps for better future relations. And then include revision and review terms. If for example, you're building a website or you're building a campaign or you're building an ad, if they can review it before you make it go live, put that in there and what those terms are. How many times can they say you need to fix it, or by what time, if you get back to them with a segment of your product, of your project, how much time do they have to review it? If they don't get back to you in a week, does it stand? That kind of thing. So again, that's back into the time frames, but that's important to put in here. And then the costs. You want the total cost, but you want to itemize the costs. And you also want to put if there's a schedule of payments and release terms. Most of my work I demand to be paid up front. I've been doing it long enough and I have enough of a reputation I can ask for that. Do I do that all the time? No, sometimes I don't, but I like everything up front. You may not be in that position. You may be building websites and you may say, give me half now and give me half when it's finished. Or you might say, give me a third now, a third when we reach this point of the project, and a third later. And if you're doing a schedule of payments, what are those terms to release that payment? That makes sure you do the work that needs to be done, but it protects both parties. The one party can say, you didn't do this, I'm not giving you the money, or you can say, hey, the contract says once I've done this, you have to pay me. So it protects both sides. And are they refundable? For example, you've itemized your costs. If you take this out, is that refundable? If he changes later and something's not needed, is that refundable? Or if you don't do a particular part of it, is any of it refundable? So definitely put that in with the cost, but be detailed again on that. The next section is penalties. Late payment terms, especially if you have a schedule of payments. If they're supposed to pay once a month or they're supposed to pay when certain things are finished, what is the penalty for being late? And what are the terms? Is it late on that day? If you say you have to pay me on the first of the month, is it late on that day where there's a penalty incurred, or is it, does a penalty not kick in after a grace period? Same for you, missed deadlines. What if you say you'll have something done by a certain time and you don't? What is your penalty that the client can ask for? And then not just to cover the penalties in this section, but also resolutions to avoid breach. For example, if you miss a deadline, well, let's take late payment. Okay, you miss a payment. There's a penalty of $25 if it's late. And what's the resolution? If it's late after 5 days but paid within 20 days, it's okay, you pay the penalty. But after 20 days, the contract is in breach. And you would go to the breach section that we'll discuss later to determine what happens. Is it voided? Do you go to court? What do you do? Termination. Sometimes you want to stop a project. Who can terminate? Can either side terminate? If they can, is it announced? Is it requested? Does one party have the right to just terminate it? Maybe they're just making an announcement and it has to be in writing or advertised in the newspaper, or it can be just a text or an email, but put that in there. And if it needs to be requested, put all the conditions in there. How is it requested? Does it need to be in writing? Do you need to give 2 weeks notice? If it's terminated, any refunds? Put that kind of thing in there. And who owns partially completed work? If you've put the website, or if you've done an ad for someone and they terminate your contract, do they still own the ads? Do they own the part of the website that you've built? Those are things that you'll want to consider. Amendments. Additional work requests is typically, in a contract like this, the biggest amendment. It could be a reduction of work. I don't need this 5th page on the website anymore, or I don't want to split test the ads anymore, or whatever that may be. It could be additional work. It could be less work. Can both parties amend? Can you as the service provider say, I'm not going to provide this anymore? and can they demand more work of you or request more work of you, and how's that covered? And then how is cost and the payment of that cost handled if it's in an amendment? If it's amended, how does that affect the cost of the contract? You're also probably going to want to put something in there about intellectual property, especially if you're doing content. Like if, for example, if I'm running lead gen and I'm building forms for a client, who owns those forms? Are they copyrighted? Are they mine? Are they the client's? If you're building language on a website, who owns that? Who owns that copyright? Are there use restrictions? Is the client allowed to use whatever it is that you've provided for them anywhere? Are they limited by geographic area? Are they limited by time frame? Are they limited by category, of where they're putting it out there? So if there are any use restrictions, and then if that gets violated, if somebody violates your copyright, that's covered under the law, but what if there's a use restriction that you've put in there? For example, I'm going to build this website, but you can't advertise it in Russia. I don't know. You might not want to go to Russia. What happens if you find out they've been running ads and letting visitors on there from Russia? What are those penalties? So think about those things. Breach of contract. Breach is when somebody has violated the contract in such a way that there's a legal resolution needed. The contract needs to be voided. It needs to be terminated. Maybe a judge needs to get involved. Who knows? Maybe not. But what constitutes a breach? Like I mentioned earlier, for example, if they are late on their payment, does that void the contract? Well, if you've put in there, you get a 5-day grace period, and after 5 days there's a penalty, but after 20 days you're in breach. Well, there you go. Then you come and now we find out, how is it handled? How do you handle a breach of contract? Or are there additional penalties and other things you might want to put in there? This is definitely something to talk to an attorney about. Resolution. All right, if there is a conflict within the contract and something needs to be resolved, how is it handled? Is there a court jurisdiction? Is it going to go to a state court? Is it going to go to a lesser county court? What restrictions are in there? Can it be by a trial by jury? Are you both parties agreeing we waive trial by jury? Those kind of things. Some contracts will allow for mediation or arbitration. And they're similar, but they're not the same. Arbitration is where you have an arbitrator that makes a decision, and that's the decision. And you go by the arbitrator's decision. Mediation is more of a negotiation where the mediator will sit down, go through the contract, go through the terms, go through the work, talk to the parties, and try to mediate a resolution that both parties are happy to. Mediators are usually not binding in any way until both parties agree. So they're more of a negotiator. When you're talking about these, who chooses them? Are they named ahead of time? Does one party have the right to choose them? If it's arbitration, is it binding? Meaning, do you waive your appeal rights in court? If, binding arbitration. In binding arbitration, that's basically what it is. I'll take the word of the arbitrator and we're done. Non-binding arbitration would be, we'll go by that, but hey, if I feel I'm had been walked on, even the arbitrator, maybe they weren't honest, maybe whatever, I can still go to court. So those are things that you'd want to cover. You might need something about confidentiality. You may not need confidentiality, but you might want it. You might want to consider it. And what is covered under confidentiality? Like if someone owns the copyright, is it confidential at how you came to that conclusion? Is your pricing confidential? Are your emails and texts that you send to each other considered private and confidential? What might be confidential in this, and what are the penalties for violating it if someone breaches that confidentiality? Is there an expiration date? Maybe you don't want anybody to know what price you've given a client, and so it's confidential, but it's confidential for a couple of years because the pricing models change and it's irrelevant after that. So put an expiration date if there is one in there. And indemnity, think about it. What if you put a website up there and the client has some legal trouble for it, or you do a Facebook ad and they get their Facebook account shut down because it violated Facebook's terms? Are you liable to them? Are you held harmless? Are there exceptions? Again, these are just things to think about, and put into the contract. And then something that I like to put into contracts is a severability clause. You might want to think if you want to include it. For short-term contracts, this really isn't that big a deal. At least to my mind. Again, I'm not an attorney. This is not advice. I'm just sharing, what I've learned in the past from doing this. The severability is, what that is let's say you have a clause in there and a couple of years later the laws change and the courts have ruled that type of a clause illegal or unenforceable. You can sever that clause out of the contract and everything else remains in place and valid and fine. That's what a severability clause does. So you might want to think about putting one in there. Consult with your attorney and see what your attorney thinks, what he or she says might be a good idea in your case. And then sign-in data. Make sure that when you're signing a contract, you use your legal signature as it normally appears in legal documents. If there is an entity, be sure the signer is authorized for that entity, especially if you're doing work for a customer and they say they're an LLC or a corporation. In most states now, at least in the U.S., you can look those up online and see who's involved. If you can't, ask them for a document that shows who the manager is or who has authorized signatory. You can take their word for it if you have a document, because if they sign it and they've given you a document that says they have authority and they don't, then they're in trouble, not you. But if they didn't have the authority and you never asked for authority or checked anything out, then that whole contract could be deemed null and void and you're out. And then think about whether you want to get a contract notarized or not. I don't usually notarize my work contracts unless it's a really large project or something very long term. That's it. Thank you very much. I do need to reiterate again, I'm not an attorney. Nothing I've said in this presentation is to be considered as advice. It's just educational. It's something that I wanted to share. I get asked this all the time, so I'm sharing what I've put in my contracts, what's helped me in the past. If you like what you see and you want to put it in your contract, consult an attorney before you actually put it into practice. You don't necessarily, again, this is just my opinion, you don't necessarily need an attorney to write every contract, but they can help you with your basic general contract that you can then use as a template for your clients. That's money well spent. So that's it. Again, my name is Ed Akehurst. Thank you very much for your time. I hope you found this informative. If you have questions, call your attorney. No, you can definitely, if you have questions about something and you want to ask about my experience with something you've seen in this presentation, I'm happy to share that with you. If you need legal advice on anything I've shared with you, then call your attorney. Thank you very much. Take care.